Namaste, everyone. A very warm welcome from India to our viewers, not just in the country, but the world over. And I try to tell people that during the time of this pandemic, not just in our country, but the world over, I hope you're all taking care, using social distancing, wearing masks, using sanitizer and soaps to keep healthy and staying put and making sure that the society, the friends, the family is taken care of. In these times, it is our humble endeavor to start with this channel with the aim and objective to not just create legal awareness, but also to bring some positivity in the world by inviting guests from the world over to gain insight into their life journey and legal journey and how they are making a difference in the world over. Having said that, let me today welcome a very, very special guest and a very old friend. We studied together in a master's. As a disclaimer, I must put it out there. Ms. Katri Paas-Mohando, who is a very prominent Estonian lawyer. She is also one of the prominent face for competition law and its evolving jurisprudence in not just Estonia, but all of Europe and the world. Katri, very warm welcome and namaste from India.
Thank you. Thank you for inviting. It's an honor to be here.
So before we start our formal question and answer series, I always ask my guest a very basic question to please tell our viewers about your initial life journey in education. And what was that moment in your life which made you decide that you want to study law and want to become a lawyer?
Okay, well, I have to say that I'm disappointing guest here. I can't really be the one saying that I knew from the start that I want to be a lawyer. It was quite random that I ended up going to do my law degree because after graduating from high school, I actually didn't have a very clear idea of what I want to become or what I want to do. I chose law because some months before graduating from high school, we had the possibility to go as they call it to be as a work shadow for different professionals, and I happened to be the shadow for a lawyer, and he was an old, accomplished lawyer who introduced us and showed us the court life and the life as a lawyer, and it was quite interesting. It didn't seem too difficult, but it seemed like interesting and well. Yeah, it seemed like a good option to pursue, and that's how I ended up going to law school.
Wow, so you had an inspiration from somebody elderly, if I may say so. So let me now take you to your legal journey. One, I would like to also inquire what is the type of legal structure in terms of education there? Because let me tell you about India. In India, we have two types of way in which you can pursue law as a career. We have a 3-year law degree, which you can pursue after doing an undergraduation course, which means you can do your first degree, and then either maybe with or without work experience, you can do a 3-year law college. And the second option, which I pursued during my lifetime, was a 5-year law course, which means the moment you're out of school, our country also offers a 5-year law education program. So we have two different setups. How is that in Estonia? Number one. And number two, because most of our viewers are young lawyers and fresh graduates, I would also like to know your take on the value of internships, moot courts, any other co-curricular activities like publications, etc. What is your take on that?
Mm-hmm. Well, the situation now is a bit different from the times that I went to law school. When I went to law school, it was 4 years. It was called bachelor degree, and after that you could do 2 years master's degree. But the 4 years master's first degree, the bachelor degree, already gave you the opportunity to do basically everything and pursue your career as lawyer. Whereas now the system is 3+2, and after the 3 year studies, you get the bachelor degree, but you can't really apply for the bar or to be a judge with the 3-year degree only. So you need the 2 years master's, and only after that you can really apply to those positions that require full qualification. So the system has changed a bit, but our 4 years degree was basically equalized with this 5 years degree that there is right now. well, there have been various technicalities out there, but even after this 4-year degree, or even after this 5-year degree that we have here right now in Estonia, a lot of students still consider it useful to go and do an LLM or further doctoral studies or something in either in local universities or elsewhere in the world. So that has been quite popular, and that's what I did. I have several LLM degrees from Helsinki, from the same program as you do, the NYU at NUS, and I also have a PhD degree from Estonia, my home university. But answering your second question about the importance of internships and moot courts and things like that, the time when I went to law school, it was perhaps a little less important, although even then I remember it very well still, my first moot court experience, and it was really interesting, and I enjoyed it a lot, and we could plead our arguments in the Supreme Court building, and yeah, it was really worthwhile experience. But I think nowadays there are many more competitions and possibilities to go and to do these kind of moot courts in various international law topics. So I really think it's a great opportunity to use. And what I've seen right now in my law firm, or the law firms where I worked before, it's the young students nowadays are very active here in Estonia in getting internships in law firms from very early on their law studies. Like already after this second year, they want to come and see how the world out there, how the field looks like. So it's very popular right now.
Yeah, I think I agree with you there, because I think the generation now, I'm not saying our generation is very old either, but the current crop of upcoming lawyers is very focused. I think they know what they want to do, and I think also the competition is immense. So we'll get to that. But I also want to tell our viewers that I personally think that Katri is a superwoman, and I'll tell you why. She has just mentioned rightly when she was studying the NYU at NUS course with us. At that point in time, I think she was working with a firm. She was pursuing a PhD. She had taken a sabbatical from that PhD and was doing the double masters. And I always used to wonder, how is she doing that? So let me put that question to you, Katri, today. After at least a decade of her, graduating from that program, what was the incentive? You had already done a great masters already. You are pursuing a doctorate. You're working. Why burden yourself into more masters?
Doing the masters abroad is not just because of your career or law studies. I think it's important for your personal development and the experience that you can have. And it's worthwhile to do it when you are free and when you are young, without the kids, without the family, without the obligations to anybody, really. So for me, going to do the extra masters was more inspired by my desire to see the world than just a requirement to get better qualifications. Of course, that was also a good aspect of it, but not the only one. And but why I chose that program, why I considered it relevant to get another degree, not just to go traveling, is I remember after my first degree, which I gained, the first LLM degree, which I gained from Finland. Well, my first degree, 4 years, was in Estonia, but then LLM in Finland. I went to do a traineeship in the European Commission. And when I was halfway through the internship, all of a sudden, all my fellow stagiaires there started applying somewhere, everybody, either for the job in the Commission or in other European institutions, or to an LLM somewhere in the States, in the posh universities in the States. And I was like, I already have a job back home. I just came here for an internship. I have a degree. I have also doctoral studies going on. Why should I apply anywhere? But well, if everybody is applying, I could as well apply. So, and maybe having a degree from some US law school would be interesting and useful to get other perspectives of the world and get better chances if I want to advance my career opportunities, either in the States or in the European institutions or anything of the sort. So it seemed like since everybody was applying, I will also apply. And then I happened to get enrolled and get this nice scholarship from NYU and NUS, and this seemed even a better option to get even wider horizons, because this program really gave us, as you very well know, the glimpse of different worlds, the perspective of the States and the American views and the American approach to the law, and also the idea of how things function there in Asia, which we here in Europe actually get very little information on daily basis. So it was a very broadening experience.
Yeah, I think I completely agree with you there, because it was like a close family. That we all got home away from home. And I must tell our viewers also that one of the toughest programs and one of its kind at that point in time in the world. And I think we are a batch of 45 students with at least people from 30 odd different countries and several continents. And I think such an enriching experience. My follow-up question to you, Katri, is because you have done 3 masters in total, and one from Finland, and obviously one from NYU and the other from NUS. And I often get asked this question from a lot of students from India. And they ask me, is one master's beneficial in terms of getting a job abroad, as in not in your country, but any foreign country that you would like to go to? And should you perceive a LLM course just as a pure academic degree, or as a stepping stone to get a better job? Or what is your take on
that? It's difficult to say for me right now, because I have never had to apply for a job really very seriously, or to take it as to do any LLMs because of wanting to advance in my career, because things are a bit different here in Estonia, because here everybody knows everyone. Of course, if you want to get the position in the public service or things like that, you have to go through a public competition. But to go for a law firm job, you need to be good, but everybody knows you already, and it doesn't really matter whether you have a degree or not, because it's a bit different here. So I can't really say whether it's benefit. You should do an LLM to get a better job or better career opportunities. It really depends on what kind of career you want to do and where. So, but I don't think that it makes sense to do an LLM just because of getting a better career opportunity. I think if you're interested in academic career, of course, then you should look for what is the best way to do that, to advance in academic sphere, and what kind of programs support that the most. If you're more up to getting a wider perspective of the world, then you can be more experiential and go and maybe do the degree as part of your project to discover the world and discover yourself as a personality, and develop as a human being and person, and get a better perception of the world, not just because of your career opportunities, but more for yourself. But if you are up for a very specific career in certain international organization, then you better look up what are their preferences and what are their LLM programs with which they do some cooperation and which give you the better chances to get selected in their competitions or get enrolled in any of such paths.
I think that's a very interesting answer, that follow what your heart says. It's also a matter of personality development, as you rightly said, because I think once you go out of your comfort zone, especially I think most of our lives we are born and brought up in our own set up in our country, in our culture, and once we go out, we tend to explore a lot more, and we definitely turn to take learnings from people from different walks of life. I think that's an excellent answer there, Katri. In fact, as I was just touching on this aspect before, that when you were in Singapore, doing your dual degree, again a very grilling course. So for viewers who think getting 2 degrees in 1 year is easy, please ask us. It's not. I can tell you that. But on top of that, Katri was pursuing a PhD, and she was also working for a firm. So from a very young viewer's perspective, Katri, I must ask you this: how does one go about managing time, especially when you are in your 20s? Yes, you have energy on your side, you have focus on your side, but how do you go about managing time, especially when you are in a different time zone? Number one, and number two, when you are doing multiple things, you are working, you are doing a doctorate, and then you are doing this drilling program. So, what would be your advice and suggestion to young lawyers who are listening to this video to go about time management? Because I know you have done it, so it's possible. So, if other people want to be as ambitious as you, how do they go about this?
There are a few tips there. First of all, don't work hard, work smart. That was that a professor in Helsinki told very early on, and that was very helpful. If you do something, for instance, you write an essay which you consider quite useful, for instance, in your studies, or you write a thesis, think whether you can use it also to get it published somewhere or rewrite a bit and use for something else. Yeah, a short article in some newspaper or whatnot. Yeah, recycle what you have already done and use it as an input. And the other big motto that I have used, that the deadline source of inspiration. If you have tight deadlines, you have to meet them and you just do them. When I studied in Singapore, I happened to also want to discover the world and go to beach and do the fun things and travel around. So I set myself very tight time limits when we had the exam weeks, because as you remember, we had their 1 week to take, let's say, 3 exams.
Yes.
I usually took the exams as fast as possible in the first 3 days, just to have the next 4 days for traveling. Why? Because I wasn't so concerned, because I had my job and my doctoral studies. I wasn't so concerned about my degrees that I would get the grades. So I thought, okay, I just want to get these things done. I studied as much as I could. We had worked hard all during the learning sessions. So, okay, I just do it as good as I can and get over it and get it done, and don't worry too much about it and don't put too much effort. So in the end, I took the exams fast and I still had the time to go and travel. So yeah, don't overthink. And in the end, I mean, the exams, I passed them all with good grades after all. So I think it's a matter of taking a right balance and not between how much you have to do and how much you can do, and don't overthink.
I think that's a great takeaway, not just for me individually, but also for people who are going to tune into this later. that one, don't overburden yourself, but in case you do, just meet the deadlines, because as the famous Nike ad says, just do it. There is no other way. You have to. If you have taken it upon yourself. Yeah. So that's wonderful. But now let me come to your professional life. Please tell us about the early phases of your career. I know that you're already working after you've done your masters, and then between Singapore and Finland, you were working. How was that phase as a young lawyer when you started your career? And compared to today, when you are, I'm sure heading a team of bright young lawyers under you, which phase is more stressful? When you started your career, and now today, when you have so much responsibility, as a senior member of a firm, and how do you, juggle between the two roles of different lawyers, as a young attorney and as somebody who is now, more experienced at the bar?
The times have changed a lot. And I think it's very different to be a young lawyer today as compared to what it was when I started. When I started, it was an interesting times because Estonia had gone through very radical changes in the 90s after the fall of the Soviet Union, and we had built a totally new legal order. And when I went to work for a law firm then, there were already, of course, elderly colleagues there who had done their successful career, and but the clients didn't know exactly what kind of legal service to order, or the clients are much more knowledgeable today and much more demanding, and you can't just deliver a 200 pages LDD report and say, well, that's what it is, and you pay for it, and you get this 200-page report and see what you do with this. So now the clients want you to be very precise and very concrete, red flags, everything of the sort. I remember when I went to work, it was in the first weeks when I was assigned, okay, do this, go to do this due diligence. What is a due diligence? Just go through these documents there and see if there is anything irregular. I'm seeing these kinds of agreements for the first time in my life. Everything is irregular for me. And I remember struggling with the first LDD report that I had to write, and I was like, what do I have to put in here? I just basically described what I had read, up some report which was long, hundreds of pages long, and then maybe perhaps the supervisors then also were not that diligent to go through and demand, what is this, why you did this, and so on. I remember I was given a very much responsibility from the early days on, much more than our youngsters get now, because nowadays there is much more supervision, and but then it was a wild west. And yeah. I was basically out of law school getting a lot of responsibility doing LDD reports, which I didn't have a clue why and how I should be doing them, or doing going to negotiations on important matters or deals, negotiating merger clearances for huge deals, which really shaped a lot the Estonian business environment then. But since I didn't know any other way, I just went and did it, and it was a hard, very sharp learning curve, because right out of the law school, I got a very much responsibility on high profile cases. Then nowadays it's much different, of course. We don't send our fresh out of law school students to negotiate with the Estonian Competition Authority to get merger clearances for the deals of the high profile cases, just like that. Yeah. But that's how it was, and yeah, it's now quite different. And I think the mentorship is much more quality today than it used to be then.
Very, very interesting point you have raised out. And I have a follow-up question because, as you rightly said, 1990 was a phase when, the Baltic tiger countries, as we popularly call them, Latvia, Lithuania, Estonia, broke away from, former USSR, as we now call it. You were growing up, then, you were in school and then you were in law school and you saw the transition, as you rightly pointed out. And now, you are integrated into the European Commission or European Union. So as a lawyer, what type of changes have you seen fundamentally, in the law? Because what I could also gather from a narrative is that a lot of senior lawyers who were working in then USSR had now, independent or a new country, a formed country, to take care of, formulate new laws, get new jurisprudence, and then also club it with the thinking of the European Union. So how has you seen this transition as a lawyer over the years that you have now been practicing, and also how this has impacted the quality of competition law, which is your core area of practice?
Of course, it has a lot has changed during these times. There has all the information that you now have to submit to the authority has to be much more quality or higher quality than it used to be then, because we all have learned and we are not doing things just to tick the box that we have done it, but we actually have to go through it. But I can't really say that when I started the things were too much easier. Of course, we have to be more precise and more detailed now, and there is much more scrutiny. But I think all in all, the quality somehow was out there then too, and maybe I can't really say that it was totally wild west then. It was, but and things have become much more demanding now than they used to be then. But we've all learned a lot during these 20 years from the start of my practice. But in like wider sense, it's still there. Nothing has conceptually changed. I mean, the market still functions in the same way, and cartels are still bad. Dominance has still to be regulated, and the abuses of dominance are still prohibited as they used to be then. So changed conceptually, but of course the approaches have and the expectations for the quality of analysis has become much more like tougher.
Interesting. Let me have a follow-up question from your answer. Estonia, obviously, since 1990s, and then we have been practicing for 20 years. Always promote free and liberalized market, and this is one argument to promote business and put the economy on a faster pace. And then on the other side, we have this huge, if I may say so, draconian competition law. Both, I mean, in India also now we have this competition law commission and competition law on the same principles of cartelization and dominant abuse position, etc. So I think the principle fundamentally are the same. But speaking of Estonia specifically, how do you as a lawyer, now think, between booming businesses and the regulators, the competition regulators? And because there is always a tiff, the regulator has a different mandate in the mind. The market, as you say, the cartels has a different mandate in the mind. So how can one draw a balance right there? What are the challenges that you face as a competition lawyer on a day-to-day basis when you think of these, tiffs between the regulator and the market?
I see mostly the tensions coming from different opinions between market participants rather than qualitatively different opinions between the regulator and the market participants. So the regulator usually gets its ideas still from, or they initiate the case in most cases, because some market participant complains that there is something problematic out there, or the society expects, or the prices are too high, or they mostly intervene there. So I don't think they are very unreasonable. They are perhaps, as concerns competition regulation, as concerns some other areas of regulation, the situation could be different. Of course, if you have to apply some harsh regulatory requirements for banking systems, or not that the regulations there are not needed, of course they are, but yeah, there might be regulations that are more difficult to understand and to reason as to how much this kind of regulatory involvement we need there. But in terms of competition, of course, there are situations where I greatly disagree with our regulator, but mostly they want the free market and well-operating market. So it's not very counterintuitive there.
Right. I have another question, more from a point of courts and how the legal system is structured. Let me give you an example of India. So in India, we have a 3-tier court system. We have district courts, or the trial courts, as we popularly call them. Then the appeal goes to a high court, which is based out of every state in India. And then we have the highest court of the country, called the Supreme Court. This is besides other tribunals in the country, from which the appeal will lie to a high court or to a Supreme Court. So for competition law, we have the Competition Commission, which decides a matter. Then they have their own appellate framework within the tribunal, and so on and so forth. The problem traditionally in India is that courts do take a lot of time in pending to decide a dispute. How is the judicial structure in Estonia? And so far as competition law goes, is there a time frame which has been regulated in Estonia, saying that this is the time limit within which you have decided a dispute, or does it also, like India, there's no upper limit to for a case to be decided?
Of course, cases take time, especially when they get to court. They take a lot of time, but I believe the situation, not knowing very well how it is in India, but I believe it's probably better. Let's say if you have a case, a competition case, then it could take a year or 2 or 3 in the competition authority, depending on the difficulty of the matter, but usually not perhaps 3 years. In the first appellate court, about a year, second instance maybe a year, and then whether you get the leave for the cassation or not, maybe another year. It's kind of okay. I can't say, of course, sometimes you would expect that things go faster. Some market participants sometimes are interested in things taking lower, of course, things taking more time and go on slower. But all in all, I think it's reasonably efficient. Given all the circumstances, I think it's reasonably efficient.
Interesting. Let's just hope that we can take few leaps from other jurisdictions also to make it a little more fast track, especially in the interest of litigation and the litigants and the people in general. So I have a different question now for you, Katri. That you have been teaching as a professor, as a visiting professor. I don't know if you're full time visiting faculty in the University of Tartu, and you teach competition law there. So my question is, which is more challenging, being Katri the professor or being Katri the lawyer?
Probably Katri the lawyer, because that's my main job. I'm being a professor. I'm only a professor part-time, I only read one course, which is competition law. I used to have another course on legislatory impact assessment, which was also, I think, very useful and important topic, but I just found that enough is enough. I don't have enough resources for that. I actually wanted very much to take up my career as professor, because if you teach something, you learn a lot. You have to be very clear in what you say and what you teach. And to be a good teacher, you have to know the subject very well yourself. So I wanted to become a professor because that would develop me as a lawyer too. And yeah, by now I have been teaching 10 years, and it's been very interesting. And I've learned a lot during that time, but and it doesn't take much time from me anymore or much effort, because I have kind of the clear routine of how I do this and how I structure my course and how I deliver the lectures, how we do the exams, how we do the discussions. So it's more or less all out there already. So and since I'm not really full-time professor, I don't have to go through all the academic administrative stuff related to the university administration in general. So I have the luxury of just going there and doing my course, and that's about it. And it's always interesting to get the interesting questions from and different perspectives from the students, from my students. So it's been interesting, and I think year by year my lectures have also improved as I have gathered more practical experience. I've been able to bring more and more examples from life and relate the things I'm teaching to what actually happens in practice and what is relevant in practice. Perhaps I'm less academic than other professors, but that's how it is.
I think that's a great amalgamation of being a practicing lawyer and also being a visiting faculty, because as you rightly said, to give live examples to students, that really livens up a lecture, because they are also looking forward to new examples to relate with. And I think that is very important, especially to budding lawyers. But I have just a small follow-up question from this. So who do you think is more challenging, the students who you teach or the clients you handle?
The clients. The clients. The students' questions are normally not that novel anymore for me. Of course, there are sometimes interesting points of view, but they are, after 10 years, they are not that different or that challenging anymore. Whereas life generates a lot of new situations which do create interesting questions from the clients too.
Very interesting. In fact, I don't know how internship is structured for students who want to pursue competition law as a career, but often I'm asked, by different law schools here in the country, how to go about internship. And I always tell them that, students should never subject them to just law firms or lawyer chambers. They must also go to businesses, and business houses to understand the dynamics, how a business runs, what are the problems they are going to face. Because to be a lawyer, on a daily basis, we are interacting with so many businesses and so many people who have their businesses or some stake, here and there. And I think that will only help, in evolving, because, I somewhat agree to you that when you are repeatedly, doing a course, the novelty of those questions start to get, saturated, it really gets diluted. So I think that is something, that even the students must think. I think the other difference which I can draw from this wonderful answer that you have given is, one, the questions from the student are not driven in terms of business or money. But when a client comes to you, they have a particular stake, that the businesses are literally hanging at the mercy either of a regulator or, some other, governmental agency. So that's very tough. But having said that, just last few more questions before we, close this session, is I hope, that pandemic has subsided in, Estonia, but in India, at least I can tell you that we are all working from home. How has working, work from home been for you? Do you think this is the future for our legal industry going forward, or would there be a hybrid culture, in the future where, perhaps a day or two in the office and then the other, time work from home? Number one. Number two, you're also a working mother. Do you think work from home is more beneficial as a working parent, or being a full-time lawyer in a brick and mortar office is better in terms of getting deliverable to clients?
Well, first of all, working from home was or working from distance was not that big of a novelty for myself personally. As you remember, and as you pointed out, I already worked from Singapore. Of course, I didn't work from there full time, but on like project basis only. But my employer was already then bold enough and flexible enough to allow this kind of working arrangement. And I think the pandemic has been the positive side of the pandemic has been that it has changed a lot in the current, in the previous very rigid general conception that work has to be done from 9 to 5 in the office. So I have had the luxury of having employers who have always understood that you don't have to be necessarily in the office from 9 to 5 every day and deliver anything like that. Now everybody has made to understand that it's possible in most cases, as concerns lawyers, to work from home, even do the court sessions from home and whatnot. So everything is possible now in terms of working from home. Has it come to stay, and how does it? Is it more efficient or less efficient? I think it depends on very much on the person and how you can make it happen for yourself. Here, for myself right now, some days I come to the office, some days I work from home, although I have the possibility to do it either all the time from home or all the time from the office, exactly how I choose. I come to the office if I want to have better internet connection or better rooms or better technical possibilities. I work from home when I have kids at home and need to take care of them or make sure that they get their lunch served or whatnot. So I think this kind of flexibility is quite workable for me, and as long as you can, if you are disciplined enough, you don't really need this 9 to 5 arrangement anyway. So it's mostly depends on the person how it works. From the employer's perspective, I do think it has made things a bit more difficult in some cases, but in other senses, it has also made things easier because, yeah, you can also do things much more according to the person's needs, and you can accommodate persons or your employees' needs and have employed those people who otherwise, if you would have those rigid arrangements, would not choose to work with you. So I think it has its pros and cons, but mostly it has been useful, this change of mindset as to how it works, this home officing or remote officing. Or what's your view about that?
I think it's great, especially as a court going as a litigating lawyer. I can say that a lot of time is saved in commuting. Definitely, the hassle of finding a parking in court, and especially because there are different courts that I have to cover in terms of practice, different tribunals, that I'm able to do with a click of a button, sitting at the convenience of my office or my home. There are days, for example, just before we started the session, I had a matter in the High Court of Delhi. And now in the evening, I have a webinar with young lawyers and law students. And without the stress of running to different places, we are at a liberty to sit anywhere in the world and connect with people. You are sitting in Estonia, I'm sitting in India, and we are still talking wonderfully to each other. And I think technology somewhere going forward, yes, we cannot let go of human connections. I think that is very important, that we need to see other people in person, and that is how nature is. We can't change that. But definitely, I think we must take the best of what technology has to offer, and more so, I think, in our legal industry, because traditionally our industry is always very opposed, to technology. be it digitization, be it using computers, be it using e-courts. And I think time has come to embrace this. I think that is very important, because in between, in India, between the first and the second wave, certain courts opened, physically, and that I think was a risk, at the end of the day, and the world knows the news that India is definitely suffering from one of the worst pandemic, death ratio. But having said that, and people I work with, my team, I think, is particularly happy. I speak to other lawyer colleagues and friends. Most of them are happy, with this arrangement of working from home, because so far as you have to submit an argument, you can do it. If you have a good internet connection, if you have a laptop, even if you have a smartphone, you can do this. And I think it also, to my mind, takes the industry in a way which makes our submissions, our articulations, and our pleadings a little more succinct. So we don't have to be verbose about things, unless obviously we have annexures, which are running into pages or dockets. That's a different thing altogether. But at the end of the day, I don't believe law is rocket science. I believe law is logic and common sense. And if we can, combine this with the use of technology, sky's the limit. And that's what I think. But having said that, I always, ask my guests, and I've taken one important billable hour, of your daily schedule. So pardon me for that, because I know you are busy and you have a pressing time schedule. But before we close this session, I always ask my guests to please have a closing comment for our young listeners. And when I say young, I just don't mean the youth. I also mean people who are young at heart and young in mind. So closing comments, Katri.
I think the most important is be at peace with yourself and be kind to yourself. That's most important. And try to be happy, and try to recognize the moments when you are happy. That's most important. That's more important than pursuing an excellent career, getting high salaries, whatever. Be happy. Try to be happy, and try to recognize the moments you are happy.
I think that's an excellent takeaway. I think no legal jargon there. And I think that's the beauty of the simple words that I always believe in. And to all the listeners who are here with us, I thank you for your association with our channel soon. And I can only appeal to you that if you like our channel, please like, share, and subscribe to it. And again, thank you very much, Katri, for joining our channel at such a short notice. And I wish you well. I wish you happiness, prosperity, and health. And until next time, see you soon.
Thank you. Bye-bye.